Good day everyone. Now we're going to discuss the RA 8293 or the Intellectual Property Code of the Philippines. First and foremost, what is intellectual property? Intellectual property pertains to the creation of our minds or our ideas. Now, what is intellectual property rights? It is the right that protects the creation of our minds, such as trademark, trade secrets, patent, copyright, and many more. Now, we're going to summarize the whole Republic Act for Part 1, Intellectual Property Office. What is Intellectual Property Office? For the state of policy, the state recognizes the importance and effective IP system for national development, encouraging creativity, technology transfer, and foreign investment. Second, the state commits to protect IP rights and promoting for the common good by diffusing knowledge. For international conventions, the Philippines will honor international treaties and agreements related to IP rights, providing the benefits for nationals of countries and that reciprocates the rights. Third is the definition of terms. The definition of terms included is intellectual property rights. It is the right that protects our minds or the creation of our minds. Second is the technology transfer arrangement. If we're going to recall, international technology transfer arrangements are arrangements involving the transfer of systematic knowledge of the manufacture of the product. Then IPO Gazette. IPO Gazette is the owned publication of Intellectual Property Office. Then for organizational structure, we have Director General, the Deputy Director General, dalawa. And under that, there are 6 bureaus. The Bureau of Patents, which grants, examines, and for patent applications. Second is the Bureau of Trademark. It registers trademarks. Third is the Bureau for Legal Affairs. Dito, we can resolve legal disputes, imposes penalties for IP violations. For example, sa patent, yang si Party B ay registered yung kanyang patent. Then, si Party C ay may business. Si Party C, hindi naka-register yung patent niya. Si Party B, registered patent niya. So, in that case, si Party B ay pwedeng magsampa ng kaso kay Party C. He can say or she can say na si Party C ay maaaring nag-commit ng violations sa kanyang IP rights. Then, we have Documentation and Technology Transfer Bureau. It supports research, educates the public, and manages technology transfer. Then we have Management Information. It ensures system operations and data management. Then we have Administrative, Financial, and HR. It handles procurement, financial management, and employee development. Then we have, for financials, the IPO is allowed to retain fees and fines collected in the funds, to operate it, to operate and improve services. That is for the benefit also for the people. Then, for other provisions of this act, the Director General has the authority to seek external assistance to other organizations. Then, pangalawa, the IPO will have an official seal, and all laws, regulations, and notices will be published under IPO Gazette. IPO Gazette is their own publication. Then, third, IPO staff are prohibited from acting as IP agents during and for 1 year after the employment. Paliwanag po. So now, we're going to discuss the part 2, which is the law of patents. Part 2 outlines the legal framework governing patents in the Philippines. It includes Chapter 1, the general provision, Chapter 2, patentability, Chapter 3, the rights, Chapter 4, applications, Chapter 5, procedures for granting patents. So, let's talk about patentability. Ano ba ang patentability? Ibig sabihin, invention must be new or novel, has an inventive step, industrially applicable to be patentable. Then, the right to patent. Ano pag sinabing the right to patent? The inventor or the heir or assignee have the right to patent with joint inventions being shared among all inventors. For example, kagaya na ng project mo, sir. Wag yan. For example, there is a certain project and apat kayong gumawa. And you wish to register it para ma-patent. In that case, hindi pwedeng si isang author lang ang kasama sa patent. If joint siya, ibig sabihin, lahat dapat kayo kasama sa name nung invention na ipapatent. Then we have patent application. An application must include a request, invention description, claims, and abstract. If an applicant is not a resident, they must appoint a local agent. Then, pang-apat, examination processes. After submission, a research for prior art is conducted. It is under section 43. Then, the application is published after 18 months under section 44. And third parties can submit observations. Ito ay under ng section 47. Then we have grant and refusal. So, sa case naman na to, if the patent meets the requirement, then it is granted. Otherwise, if hindi niya na-meet yung requirement sa patent, hindi siya magagrant. Patents are effective upon publication in the IPO Gazette under section 52. Then, number 6 is the maintenance and term. Patents last 20 years from the filing date It is under Section 54. Annual maintenance fees are required. Failure to pay. This may result in patent lapse. So yan ay under ng Section 55.2. Then, for corrections and changes, the director can correct mistakes or applications are published in the IPO Gazette. So, tapos na tayo sa chapter 1, 2, 3, 4, 5. We're going to discuss now. Part 2 pa rin, pero chapter 6 naman. Cancellation of patents. In cancellation of patents, we have petition for cancellation. Anyone can petition to cancel a patent for a reason, like lack of novelty, insufficient disclosure, or immorality. Sa notice and hearing naman, upon petition, the patentee and interested parties are notified and the hearing is scheduled. Then, for committee of 3, in technical cases, a special committee may decide on the cancellation and its decision can be appealed. So, punta tayo sa chapter 7, which is the remedies of a person with a right to patent. First is patent application rights. If someone other than the applicant is declared to have right to patent, they can take over the application, file a new one, or cancel an issued patent. So, para naman sa true inventor's rights, if inventor is wrongfully deprived of a patent, they may substituted as a patentee or request the cancellation with potential damages awarded. So, yun lang yung content ng chapter 7. Let's move to chapter 8, which is rights of patentees and infringement of patents. Unang-una dito ay ang rights conferred by patent. A patent owner has an exclusive right to make, sell, or import his products. For example, skin white lotion. Those are the products na pwedeng i-manufacture, i-benta, i-import sa ibang bansa since registered siya sa patent. Then, pangalawa is limitations on patent rights. Patentees cannot prevent certain uses like those involving previously sold products. Then, prior user rights. A prior user who has used the invention in good faith before the patent was granted can continue using it. Government use. The government can exploit a patented invention without the owner's consent for public interest or to address anti-competitive practices. Then, infringement. Ano ba yung infringement? Unauthorized use, sale, or importation ng patented product. Okay? The patentee can seek damages and injunction. For example, si Juan de la Cruz ay may business. Nagbebenta siya ng mga sabon. For example, sabon. And si Mara, binenta yung kanyang sabon without his consent. Okay? Or nagbenta siya ng fake na sabon na katulad ng patented na sabon ni Juan de la Cruz. So, dito mapupunta yun. the patentee can seek damages and injunction. Okay? Damages. Infringement damages can be based on actual losses on a reasonable royalty. In severe cases, damages may be trebled and the infringing goods may be destroyed. Okay? So, yun. Then, next is criminal penalties for repeated infringement. Infringement after a court judgment can lead to criminal charges with penalties including fines and imprisonment. So, sabi ko kanina, yung kay Juan de la Cruz and kay Mara, if si Mara ay hindi talaga nadadala, paulit-ulit niyang ginagawa yung pagbibenta ng sabon na kapangalan or kabrand talaga nung kay Juan de la Cruz, then pwede siyang makasuhan. Okay? So, now, we're going to summarize chapter 9, chapter 10, chapter 11, 12, and 13. So, ano ba yung section 93? A patent can be exploited without the owner's consent in case of national emergency, public interest, health and security, anti-competitive practices, or non-commercial use in the Philippines. Okay? Section 94, petitions based on non-commercial use can only be filed after 4 years from the application or 3 years from grant. Other grounds can be filed anytime. Okay? Punta tayo sa chapter 11, Assignment and Transmissions of Rights. Under section 103, patents can be assigned, inherited, or licensed. Section 104, patents can be fully or partially assigned with territorial limits or disarray. Section 105, assignments must be in writing, notarized, and certified. Section 106, the IPO records assignments and licenses. Unrecorded assignments are void against new buyers unless registered within 3 months. Then Section 107, joint owners can use or sell the inventions individually but need consent for licensing or assigning rights. Okay? Now is registration for utility models. Utility models must be new. Okay? Industrially applicable, but it does not need inventive steps. Registration lasts for 7 years, non-renewable. Okay? Sinasabi na if hindi mo na meet ang requirements ng patent, you can apply for utility models. Okay? Then for industrial design. For the definition of industrial design, it refers to the unique appearances of a product, either 2D or 3D. Protection requirements. Design must be new, original, functional, or immoral designs are not protected. Application must include a request, applicant's info, product details, design representations, and the creator's name. For term of registrations, it lasts for 5 years. Renewable twice for 5 years each. Late renewal allowed with subcharge. Cancellation. A design registration can be cancelled for lack of novelty, non-compliance, or similarity to the original application.
A pleasant day to everyone. So this is the continuation of our report, the RA 8293, or also known as the Intellectual Property Code of the Philippines. So I'll be discussing the part 3 entitled The Law on Trademarks, Service Mark, and Trade Names. Section 21, the definition of terms. Mark means any visible sign capable of distinguishing the goods or the trademark or service or the service mark of an enterprises and shall include a stamp or mark container of goods. Trade name means the name or designation identifying or distinguishing an enterprises. Bureau means the Bureau of Trademarks. Director means the Director of Trademarks. Regulation means the rule or practice in trademark and service marks formulated by the Director of Trademarks and approved by the Director General. So, to simplify it or to summarize it, marks means kapag pumasok sa utak natin ang salitang mark, lagi nating tatandaan na it was all about the physical sign or the design. So, katulad na lang, for example, the sikat na fast food here in the Philippines, this sign or this mark is kilala bilang tinatawag na McDonald, and that McDonald is the trade name itself. Section 122. How marks are acquired. The rights and marks shall be acquired through registration made validly in accordance with the provision of this law. Section 123. Registrability. A mark cannot be registered if it consists of immoral or deceptive or scandalous matter, or matter which may disparage or falsely suggest a connection with person, living or dead, institution, beliefs, or national symbols, or bring them into contempt or disrepute. A mark cannot be also registered if it consists of the flag or coat of arms or other insignia for the Philippines or any of its political subdivisions, or of any foreign nation or any simulation. A mark cannot also be registered if it consists of a name, that portrait or signature identifying a particular living individual except by his written consent, or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any except by written consent of the widow. A mark cannot be also registered if it is identical with a registered mark belonging to a different proprietor of a mark with an earlier filing or priority date in respect of. A mark cannot also be registered if the same goods or services or closely related goods or service, or if it nearly resembles such a mark as to be likely deceive or may cause a confusion to buyers. So, mark cannot be also registered if it consists of shapes that may be necessitated by technical factors or by the nature of the goods themselves, or factors that affect their intrinsic value. If it consists color alone unless defined by a given form, or it may contrary to public order or morality. Section 124. Requirements of application. The application for the registration of the mark shall be in Filipino or in English and shall contain the following: a request for registration, the name and address of the applicant, the name of a state of which the applicant is a national or where he has domicile, where the applicant is juridical identity, the law under which it organized and existing, the appointment of an agent or representative if the applicant is not domiciled in the Philippines, where the applicant claims the priority of an earlier application, he names the good or services for which the registration is sought. A signature by or the other self-identification of the applicant or his representative. So basically, the trademarks cannot be acquired if it's not registered to us. For example, I have a trademark, the other proprietor has a trademark, same as mine, so magkapareho kami ng trademark. But then, kahit na ako ang naunang gumawa ng trademark na yun, then hindi ko siya na-registered agad and the other proprietor has na-registered niya yun ng mas maaga, then he have the rights of that trademark even though ako yung naunang gumawa nun. Section 145 Duration. A certificate or registration shall be remain in force for 10 years, provided that the registrant shall file a declaration of actual use and evidence to that effect, or shall have valid reason based on existence of obstacle to such use, as prescribed by the regulation within 1 year from the 5th anniversary of the date of the registration of the mark. Otherwise, the mark shall be removed from the registered by the office. Section 146 Renewal. A certificate of registration by renewed for a period of 10 years as its expiration upon payment of the prescribed fee and upon filling of request. The request shall contain the following indication. A. An indication that renewal is sought. B. The name and address of registrant or his successor in interest hereafter referred as right holder. C. The registration number of the registration concerned. D. The filing date of the application in which resulted in the registration concerned to be renewed. E. Where the right holder has representative, name and address of that representative. F. A signature by the right holder or his representative. So, upon discussing the part 3, I hope na malinaw sa inyo kung ano ang trademark, kung paano ito ma-acquire, paano ano ang mga requirements for application, the filling the date, the opposition, the renewal, the duration, and the damages requirements of notice. So now, let us proceed in part 4, the law of copyright. Rights of copyright's owner. So 1. Economic right. This allow the creator to financially benefit from their work. The rights include reproduction, the right to make copies of the work, distribution, the right to distribute copies to the public, public performance, the right to perform the work in public, broadcasting, the right to communicate the work in public via broadcasting, adaptation, the right to modify or adapt the work. Number 2, the moral rights. This protect the personal or reputational interest of the creator. Attribution, the right to be acknowledged as the creator. Integrity, the right to object to any distortion or mutilation of the work that could harm the creator's reputation. So, duration of the protection. Literary and artistic work protection lasts from the lifetime of the author plus 5 years after their death. Photographic works and audiovisual works protected for 50 years after the publication. Next. Infringement and remedies upon copyright. Infringement occurs when someone uses a copyrighted work without permission, violating the creator's economic and moral rights. So the remedies for infringement includes injunctions, court's order to stop the infringing activity, damages, compensation or losses incurred due to infringement, seizures, confiscation of infringement copies and equipment used to produce them. International Convention. The Philippines is a signatory to international treaties such as Berne Convention, which establishes standards for copyright protection and ensure that the Filipino works are protected in other countries. By understanding the provision of RA 8293 or the Intellectual Property Code of the Philippines, creators and users can better navigate the complexities of copyright law and ensure that the intellectual property rights are respected and upheld. Part 5, Final Provision. So, Section 234, Abolition of the Bureau of Patents, Trademark and Technology Transfer. The Bureau of Patents, Trademark and Technology Transfer under the Department of Trade and Industry is hereby abolished. All the unexpected funds and fees, fines, royalties, and other charges collected for the calendar year, properties, equipment, and records of the Bureau of the Patents, Trademark and Technology Transfer and such personnel as may be necessary and are hereby transferred to the office. Section 235, application pending on effective date of the Act. All application for patents pending in the Bureau of Patents, Trademark and Technology Transfer shall be proceeded with and patents thereon granted in accordance with the Act under which said application were filed. The said acts are hereby continued to be enforced. To this extent and for this purpose only, now notwithstanding the foregoing general repeal thereof, provided that the application for utility models for or industrial designs pending and the effective date of this act shall be proceeded with in accordance with the provision of this act unless the applicants elect to prosecute said application in accordance with the act under which they were filed. All application for registration of marks or trade names pending in the Bureau of Patents, Trademark or Technology Transferred at the effective date of this act may be amended, if practicable, to bring them under the provision of this act. Section 236. Preservation of existing rights. Nothing herein shall adversely affect the rights on the enforcement of the rights and patents, utility model, industrial designs, marks, and works acquired in good faith prior to the effective date of this Act. Section 237. Notification on Berne Appendix. The Philippines shall, by proper compliance with the requirements set forth under the special provision regarding developing countries, including the provision for license grantable by competent authority under the appendix. Section 238. Appropriations. The funds needed to carry out the provision of this act shall be charged to the appropriation of the Bureau of Patents, Trademark and Technology Transfer under the current General Appropriators Act, and the fees, fine, royalties, and other charges collected by the Bureau of the calendar year pursuant to Section 14.1 and 234 of this Act. Thereafter, such sum as may necessary for its continued implementation shall be included in the Annual General Appropriation Act. So, Section 40, Separability. If any provision of this Act or the application of such provision to any circumstances is held invalid, the remainder of the Act shall not be affected thereby. Section 241. Effectivity. This Act shall take effect on January 1, 1998. So that's the end of our reporting upon discussing Week 17, Republic Act 8293, or also known as the Intellectual Property Code of the Philippines.